Six. We're live.
Okay, welcome, folks. This is a joint meeting of the House Corrections and Institutions Committee along with the House Human Services Committee. It is Wednesday, May 6th. And we are going to be going through a new draft that's been drafted for S 193. This is, folks are very well aware, is being worked on by 4 committees, at least 3, if not 4. And we're just trying to figure out how to combine the work that the individual committees are working on. And Eric Fitzpatrick has worked with House Judiciary, Katie McFlynn has worked with House Human Services Committee, as well as House Corrections and Institutions Committee. We're kind of at the point, particularly for House Corrections and Institutions Committee, I'm not so sure about Human Services Committee, but we kind of have to see the whole package at this point. Even though the bill physically sits in House Judiciary Committee, we're all working on separate pieces of it, and we need to see the whole picture, and then we'll figure out what the next steps will be. That makes sense.
Yeah. So let's just do, we always like to do a brief round of introductions in our committee, so that whoever is watching can tell who's in the room. So we're not going to go all the way at the outside, but we're just going to do around the committee. So Representative Steady, why don't you start us off?
Representative Steady, Milton, East Milton, Westford.
My name is Zahn Eastus. I live in Guilford and I also represent Vernon.
Doug Bishop, one of Colchester's representatives.
Good morning, I'm Dan Noyes. I represent Wolcott, Hyde Park, Johnson, and Belvedere.
Hi, good morning. Eric McGuire, I represent Rockland City.
Hi, I'm Esme Cole and I represent Hartford.
Hi, Ray Garofano. I live in Essex. I also represent Essex Junction.
Teresa Wood from Waterbury, and I also represent Bolton, Buellscore, and Huntington.
Alice Emmons, and I represent Springfield.
Sean Sweeney, I represent St. George and the northwest part of Shelburne.
Brian Minier from South Burlington.
Kevin Winter from Ludlow, Shrewsbury, Mount Holly.
Mary Morrissey from Bennington, second to District 5.
Joe Ludo, St. Albans City.
Will Greer from Bennington and also Bennington.
So it would be great. We can have both Ledge Council members up. You need to pull up another chair, it looks like. This is probably the most colors I've seen in the bill. We have all the colors of the rainbow here. So which is representative. And as Chair Emmons said, anybody in the audience or tuning in from outside the building, you can find this on both of our committees' websites, on the Human Services under Katie's name and the same in your committee. Okay.
So you're gonna put this up on the screen?
That's exactly what I was wondering. That'd be helpful.
That would be helpful. It'd be easier to read. Paper copy, it's really kind of.
Oh, I know the colors.
The green and the blue is tough.
Yeah.
Well, if you used your iPad,
Yeah.
Chair Emmons, you could see it.
Yes, I know. I know.
Yes, we don't.
Yeah, I don't it.
Good morning. Katie McLean, Office of Legislative Counsel.
And Eric Fitzpatrick, also Office of Legislative Counsel. Nice to see everybody.
I guess two disclaimers before we get started. One is that I have a couple bills on the Senate floor, so I'm going to be hopping back and forth. The second is that you'll see that we don't have sort of the normal lead-in language that we have saying that this is a strike-all amendment and which committee is offering it. I think Eric and I are still navigating this process, and I know you are also navigating this process of what will be offered by whom, when. So this is a compilation of work from multiple committees. This is a starting point. There are probably multiple adjustments that can be made as the committees talk about what's on the page. But you'll see that we have tried to capture different committees' proposed changes in different colors. To the extent that there are conflicts between committees, not quite sure how to handle those on paper at this point. because we don't know who owns this, which committee owns this document. So that's sort of where we are right now.
Can you make that a little bit larger on the screen? Or not?
You mean covering more lines, or do you mean larger and
No, larger, print larger.
Print, larger print.
like that?
Yeah.
Oh, that's much better. It's not like a committee room, you're sitting a little further away.
That's right.
Okay, well, I guess I'll jump in first. So House Corrections and Institutions had a conversation about adding this legislative intent language. That it is the intent of the General Assembly that the Department of Corrections shall not operate or staff a forensic facility, with the exception that employees of the Department of Corrections may provide security around the outside perimeter of a forensic facility if it is co-located on the grounds of a correctional facility. That committee also had a conversation about maybe having some of this language in the statute itself. So that is not integrated here, but that is something that might require more conversation as you see the draft.
So continuing on to section 2 now, and this is language that's been worked on by the House Judiciary Committee, and stepping back from the words themselves just for a moment to sort of reiterate the big picture for the committees for a moment. And that's that this is describing who it is that would be placed in the forensic facility in the first place. And you'll see that there's some technical language that changed at the very beginning that is just using the word placed, because these folks could conceivably be in Department of Corrections custody, because as you see in the very first subdivision, or sorry, the second subdivision, they might be being held without bail. So they might be in a DOC facility in the first place. They could be under Department of Mental Health custody, subject to an ONH, an order of non-hospitalization. That could be the place where they are currently. So rather than specify that up front, it's just saying that, well, the person would be placed there. So wherever they are prior to that, whatever status they are in prior to the placement, this is the qualifying criteria for who it is. It's a universe of people that would go to the forensic facility. And I think the committee's probably been through these items a number of times, but just to kind of review them, this has to be punishable by a life sentence at subdivision 1. And then they're either being held without bail, or if they're not being held without bail, they have to have a qualifying condition that upon the person's release would create a substantial risk of bodily injury to someone else. And they have to not currently be receiving treatment through an order of non-hospitalization, an order of hospitalization. So in other words, they're not currently in the DMH process being treated inside a hospital. But they could be, as I just mentioned, could be outside hospital being treated on an ONH, order of non-hospitalization. You'll see that the prior draft also, and so those folks are excluded, if you think about it. That's the way that language is phrased. They're not currently receiving hospitalization treatment. And the prior draft had also excluded folks who were subject to commitment to Dale. That's the Act 48 process, 248, sorry. So people who were excluded in the prior draft were those who were subject to the Act 248 process. And in other words, folks who were, and this, I had this posted on the website. I'm sure the committee is very familiar with the language, which is someone who is found to be a person in custody, care, and rotation. And that language is incorporated here further along in the draft. So in other words, although in the upfront portion of who is covered by this, you'll see the person isn't necessarily excluded right away, but there's an off-ramp that's provided in the new draft that we'll see when we get to it, as well as a possible finding up front that the person would not be subject to the forensic facility placement if they're someone who has an intellectual disability and is otherwise would be subject to this Act 248 process. So that's kind of the structure. You'll see, so what happens if the person is placed there? Well, in that case, they have a review. You'll see subdivision 8 every 6 months. So they aren't perpetually at the facility without having their status reviewed. There's going to have to be a review at least every 6 months, and then every 6 months thereafter. So 6 months from the date of admission, and then every 6 months after an order of continued restoration treatment. But also you see subdivision B, and this relates in particular, can relate to the Act 248 population that I just mentioned. You'll see, in addition to the 6 month reevaluation. There's also a reevaluation whenever and this is some new language now, the Agency of Human Services Medical Director is the person who has the position that makes these clinical decisions at the facility. So if that person determines that the person committed there, and you'll see that's below the highlighted language, is likely competent to stand trial, or that it is unlikely that the person's competency can be restored. So again, that's a determination that can be made by the medical director at any time. Could be day one. Don't have to wait for that 6-month initial period that automatically happens. So there's an automatic reevaluation at the 6-month date. But it could be day one, as I said, that the person is committed there, placed there, I should say, that the medical director determines that the person is not likely to have their competency restored. And that could be somebody who is subject to the Act 248 proceeding, because in other words, because of an intellectual disability, perhaps that person won't ever have their competency restored. And that could be determined right away, or at least that the medical director determines that it's likely that the person's competency will be restored. Then they could have a reevaluation right away. And court would have to, you see subdivision 2 there, that's the case, court has to hold a hearing. So there would have to be a consideration of whether or not that person might be subject to release. Prior to the hearing, the results of evaluations get given to everybody, the court parties. So at that hearing, right, it's either at the 6-month juncture or upon the certification of the medical director. It could happen sooner, but either way, the court's going to have to make a finding one way or the other. Either the person is competent to stand trial, in which case they would be, you see that subdivision 3A there. The court finds they are competent, then they get restored to the status that they were in before they got sent to the forensic facility in the first place. Because the court's saying, well, now they're competent. Now they can be sent back to the criminal division for the hearing related to their criminal charges. Unless, and that's some new language there, if the court finds that doing so is likely to cause the person to again become incompetent, because if it's actually transferring them away from the facility is the thing that's going to render them incompetent again, doesn't make logistical sense to do it. In that case, they could hold the person there pending the resumption of the criminal trial.
Eric, can you just review that one more time? I find this clause confusing. Can you say that again?
Right. So the court's at this 66-month hearing, say, or at a, earlier if it turns out that the medical director thought it should happen earlier. But at that hearing, the court has to decide, is the person competent to stand trial or not? And if the person says, if the court finds, yes, they are now, maybe because treatment has happened or whatever it may be that has restored the person's competency, then the court restores them to the status that they had before they were sent to the facility in the first place. So that might have been DOC supervision, that could have been DMH custody, whatever it was, prior to them being sent there. The court sends it back there, and then having been found competent, the criminal proceedings can resume because they were on hold.
I get that part. I don't get the highlighted part.
Right. So this is a suggestion from the Defender General. And that suggestion was that, well, and I think his testimony was this sometimes can happen, that if the restoring the person to that status is the thing that will actually make them not competent to stand trial again, then the court wouldn't do that if it finds that doing so is likely to cause the person to again become incompetent. And instead, again, there being a finding that the person is competent, it couldn't stay there indefinitely, but they could stay at the facility until the criminal division was able to ramp up and start the criminal proceedings.
So all this really means is that they would stay at the forensic facility, wherever that is, whatever that is, and as opposed to being remanded back to whatever the prior custody arrangement was.
Exactly.
Okay.
Okay. Right.
And I think the confusing part was the likely to cause the person. So it sounded like with absent the services that they may be getting at the forensic facility, they could return to incompetency. Is that essentially what that's saying?
Yes. So perhaps in a given situation, the person should continue to receive those services pending trial rather than being sent back to some other custodial status where they wouldn't get them.
And then I guess my only question would be then, if their competency is that fragile, it just,
Sometimes referred to as fluid.
it's fluid,
Yes,
okay?
yes.
That's another word. That just leaves me with questions. So, but I understand the words now. Thank you.
Right, sure.
Could I flag something here?
Yeah.
House Healthcare has a different take on this. You'll see it later. So this is something you'll have to, all the committees will have to pay attention to as you move forward. And their recommendation was that somebody who's regained competency stays at the forensic facility pending their trial and for the duration of their trial. So you'll see that later on in the draft. You'll have to figure out how you want to handle that.
So I just want some clarity. So if they are deemed competent to stand trial, the court can order the person to go back to the same custodial status that they were in,
Yes.
and that would be at the forensic facility. Or could it be in a correctional facility?
No, it would be whatever status they were in prior to being transferred to the forensic facility. So in other words, the court's finding, unless it finds that doing so is likely to cause them to again become incompetent. If the court doesn't find that transferring them out would cause them to become incompetent again, unless the court finds that, then they would transfer them out of the forensic facility into whatever status they were in prior to being transferred, placed there in the first place. Now, it could still be within DOC supervision.
Because they could have been placed there first before they went to the forensic facility.
Right.
Is it conceivable that they were just in the community and they went from the community directly to this facility?
I think, yeah, like they could be on an ONH, for example.
Okay. Go ahead, Representative Dwyer.
Thank you. Everything, can you share with me the exact legal trigger for placement specifically, what court finding or status must exist before a person may be ordered to the forensics facility? And is there any pathway under the bill for placement outside of an active Vermont criminal case?
I did not follow the second part of your question, so let me answer the first one first.
The first part being, can you walk us through or just point the exact legal trigger for placement specifically?
Right.
What court finding or status must exist before placement?
Right. So that's the first several subdivisions under subsection A. So criteria number one has to be charged with a life sentence, an offense with a possible life sentence. So I can't remember if I ever distributed that to the committee. If it's not, it's on the House Judiciary Committee's webpage, but there's between 10 and 15 offenses, criminal offenses in Vermont right now that have a maximum life sentence. So it would have to be one of those offenses. So that's criteria number one.
So the criteria is you've been charged with one of those offenses, legally charged.
Correct.
So that's the exact trigger, the legal charge.
Yep.
Okay. And then the second piece, is there any pathway under this bill for placement outside an active Vermont criminal case?
You mean, in other words, there isn't a pending criminal case?
No pending criminal case. So I go back to the question that Chair Wood was presented in regards, can somebody be taken from the community and placed into that facility without an active Vermont criminal case? The trigger is you need an active case is the trigger. Therefore, there would be no pathway for somebody to be placed in that facility without an active case.
Well, that's true for people with respect to the question of someone being found incompetent to stand trial, which is the portion of the population that we're looking at right now who could end up in the facility. And when I mentioned the ONH, I didn't mean to imply that that person would be in the community on an ONH in any other status other than with a pending criminal charge, because that absolutely is required for the method of ending up in the facility that I was describing. So yes, if the person had been charged with a life sentence but they're prior to the determination of incompetency that the criminal court has to make. It's not in this bill because that's sort of precedes this bill, but the criminal division has to make this finding of a person not being competent to stand trial. And as part of that process, a person could be, while the charges are pending, because an evaluation has to be made, and sometimes the person will be in DMH custody at that time. And in that situation, person could be in the community on an OA. So that's what I meant. So yes, there is the criminal charge pending in that situation. It is also possible that you may recall this, that in addition to the competency avenue to the forensic facility, it's also possible for a person to be found not guilty by reason of insanity. And for that, for an offense punishable by a lifetime max, the other, that has to be one of those offenses. But in that situation, technically there isn't a criminal charge still pending. They were charged with a life offense. It's not still pending because they've been found not guilty by reason of insanity. But in that situation, you'll see when we get to it, there's language that provides the criminal division with continuing jurisdiction over the person to send them to the facility in that situation.
So so the term incompetent to stand trial, is that a diagnosis?
It does. It's a legal term. I mean, there is an evaluation for that, a clinical evaluation, but and I'll defer to people with more medical experience than myself. It's a legal standard, not a medical one. So the competency to stand trial is the legal, in the legal definition of that, it's that a person either cannot understand the nature of the charges against them or they cannot participate in their own defense. So again, it's not a clinical medical thing. It's their ability to participate in the criminal proceedings.
I appreciate that clarification because the point I'm getting at is that the placement is based upon legal triggers, not diagnosis.
Let's see. Yeah, I think that's right. Yeah.
Thank you.
Yep.
Connor?
Yeah, I think it's similar to Rep McGuire's question. I'll just ask it again there. So I think the part I'm struggling with is you could have somebody incompetent to stand trial, but not accused of one of those triggering crimes that carry like a life sentence. But you could be somebody who has multiple aggravated assaults. You're clinically volatile. A clinician shows that. And you have a propensity to commit danger in the community, but you're not accused of one of those types of crimes. You're not eligible for this facility.
That's correct.
Okay.
But that's a policy decision for you if you wanted to expand the list of crimes for which someone would.
I'm having trouble equating what you're sentenced of being how dangerous you are to the community rather than what a clinician finds you. So that's just a point I'm going to keep trying to bring up. I think we're just kind of talking to ourselves and not targeting necessarily the most dangerous people who would need to be in a facility like this if we limit it to the sentencing and not the diagnosis. So that's the idea. It's a policy decision, but that's an issue I'm having for everybody listening.
Representative Steady has a question.
More of a curious question. You said that they're found insane, they can't stand trial.
Correct.
What happens to them now? Where do they go now?
Well,
Yes, that's where I'm curious.
Right. They could, and it's kind of partially in response to Representative Casey's question as well, provides a little bit of information because there is an existing process. Remember that if a person is found not guilty by reason of insanity and they're a danger to themselves or others as a result of a mental illness, so it's a more narrow criteria, not from a legal perspective, but more from a clinical perspective, as a result of a mental illness, or if a person is found not guilty by reason of insanity and they are a person in care of custody and rehabilitation, there are other methods now that the person could be committed elsewhere. For example, could be committed to the Department of Mental Health, could be committed to Dale, for example, depending on the basis for the person being found not guilty by reason of insanity. What's the basis of the mental health condition? But there is, nevertheless, some folks who aren't covered by existing law. I think that some people, some proponents of the bill view that as part of the space that the bill is intended to fill.
So would they go back into society then?
They could.
Okay, thank you.
So I think we have to be really clear of who would actually go into a forensic facility. You've got to look at 1, 2, 3, and 4, and all of those have to be in place. It's not an or. The only place there's an or is in 2, where a person, they need to be charged with life sentence, offense punishable by life sentence. They need to be held without bail. Or if person's not held without bail, you have to prove that upon the person's release would create a substantial risk, bodily injury. The person is not currently receiving treatment under an order of hospitalization, and person's been found not competent to stand trial. Those 4 qualifications have to be in place. It's not one or the other. It's all 4, because you have an and. Line is on the bottom line above 4. It's an and. Am I off base on this?
No, you're exactly right. It's got to be all 4.
Go ahead, Representative Cole, and then we're gonna have to keep moving because we have an hour and we need to get through the whole bill. I know. Yeah, go ahead. But I think it's bringing up questions that sort of, sorry, go ahead, Representative Cole.
One piece of this is, it seems to me that if you meet all criteria 1, 2, 3, and 4, and the and included, but you are charged with a crime in a different state, for example, there's nothing preventing that individual meeting all these criteria from being housed in the forensic facility in Vermont, correct? If some kind of agreement happens between another state and Vermont DOC, or not DOC apparently, because we changed that in the first section, but is your question, could somebody who meets these criteria for a forensic facility receive forensic facility type services out of state? Yes, if the charge was a charge that happened in another state, basically, but maybe it met the criteria of a life sentence in either state.
You mean they committed a criminal act in New York?
Yeah, or, yeah.
Charged by the prosecutor in New York.
Yeah.
I think generally speaking, the Vermont courts would be without jurisdiction over of a charge like that. So while the language doesn't specifically exclude that situation, I think it would be a jurisdictional question of whether or not that person could be transferred to the forensic facility or not. It's an interesting question. I want to look into it a bit more. But I wonder about whether the court would have jurisdiction. I don't have a 100% clear answer either. So
Thank you.
it's a good question.
And just before we move on, I want to make sure that I'm understanding on B, 3B, that's been struck out. Is that striking out people who have been, is not currently under Act 248? Is that what 18 VSA 8845 is?
Yes, it is. And 4823 as well.
Okay.
That's sort of a reference to, but it's sorry, go ahead.
So my question is, so if they're a person who has mental health challenges and is receiving those services through an order of hospitalization, they're excluded. But a person who is receiving services under Act 248 is not excluded.
Not excluded under that provision, but there's another lengthy section of the bill that was added that
that's a pathway out once you're in. This is, you don't get in.
I think that's correct.
I don't understand why that's struck out. And I guess maybe I'll talk to the chair.
Yeah, I think that is policy decision.
Yeah, okay, all right. So we can move on now.
So, but that same question does sort of segue me, I guess I mentioned it earlier, but the person, you're right, that they're not being excluded completely in the first instance. But if the medical director thinks before they've even started their commitment process that it looks like the person's competency can't be restored, they can immediately request the hearing. So in other words, they don't have to wait the 6 months necessarily.
If they have already gone through the process and they've been committed to Dale, they've already gone through that process of determining their competency. So I'm just gonna flag this as problematic.
Right. So that brings us, I believe we were at the sort of 6-month hearing, right? So again, as we mentioned, the 6-month hearing, they find that they're competent. The court,
Yeah, we were already down through, we were on 3B.
all right, so if they find that, we already went through, if they found that they were competent, then they go back for trial. If the court finds that they're not competent, well, then they stay at the facility for continued competency restoration proceedings. Again, remember, it's always subject to that 6-month review or a review at any time earlier than that if the clinical services director thinks they might be competent. So this brings us to the restorability concept as well, because that's just about whether the person's competent or not. At any time, either a party or the clinical services director, as we mentioned, that could be right away after they are transferred there. They can ask that this reevaluation, this periodic reevaluation include an opinion on whether the person is restorable to competency or not. And this is another juncture, because if somebody asks for that, then the court's got to give an opinion on that as well. And there's another sort of, you could think of it as a fork in the road at that point, because the court's going to have to find one way or the other that either the person's competency can be restored or the person's competency cannot. So you'll see there here 2 options, subdivision 2 and 3. If they find that the person's competency can be restored, then they order continued treatment. So continues on at the facility. But if the court finds that the person's competency can't be restored, then there has to be a hearing within 60 days. Because you think about it, you're in a different sort of universe now. Because now there's been a finding that despite all this treatment, the person's competency is not going to be restored. And in that case, the court's got to make a decision about dangerousness. That's essentially what the decision is next. All right, if they can't be restored, are they dangerous or not? And in the big picture, before you look at the language, what the court is going to be able to find is either the person is dangerous, so they may not be able to be restored, but their release would cause a danger to other people. And if that's the case, then they stay at the forensic facility for continued treatment, but it's a different type of treatment in which they are acknowledging that the treatment might be different, and they're then subject to a 12-month review rather than 6-month review, then it's finding the non-restorability. But if they find that the person is not dangerous, well, then the person has to be released, because you think about it, they've been found to be not restorable and not dangerous. So in that case, there no longer is a basis for keeping the person at the facility, and they are released under supervision, supervised conditions that are laid out in the statute for that. So that's the big picture. Finding number 3, though, remember, we're at this hearing of whether the person's been found, whether or not the person's restorable, could be dangerous, non-restorable, keep the person there under different treatment. Could be not dangerous, not restorable, person's released, or it could be that the person would be subject to Act 248. And that's the off-ramp that the chair mentioned a few minutes ago. So that if it turns out that they're subject because of an intellectual disability, potentially dangerous, or at least a prior conviction, then if they meet that definition of a person in need of custody care and rehabilitation, then they would go back to Dale through that for the continued Act 248 treatment that is the case under current law. In fact, the language is basically tracked from the existing Act 248 language to this avenue of when a person would go be transferred to Dale's custody. That's the big picture. Any questions there before we look at the language?
This is brief.
Go ahead.
So does this bill limit the eligibility strictly to individuals who are in the criminal justice system and found not competent to stand trial regardless of diagnosis? Correct? Regardless of diagnosis, this bill is strictly for individuals who are in the criminal justice involved and found not competent to stand trial.
Or not guilty by reason of insanity. That's the only thing I would add. But yes, otherwise.
It's a narrow group, very, very narrow group.
Yes.
Okay, thank you.
So, sorry, what? So the 60-day hearing, prior to that 60-day hearing, there has to be a forensic risk assessment. You see, and the risk assessment has to include a number of pieces, which you'll see itemized under subdivision B. The part of the language that's included in addition, added by House Judiciary in its most recent draft as recommendations for treatment and supervision that support the person's success, mitigate risk of aggression and violence, and more relevantly to what the committee was just discussing, the examiner's opinion as to whether the person is a person in need of custody, care, and rehabilitation. So remember, because I said that at this hearing, the court's going to have to be deciding, are they dangerous and retained at the facility? Are they not dangerous and released? Or should they go back to Dale through the Act 248? And that recommendation that the examiner makes informs the court decision about whether to send the person back to Dale. It's the decision based on the existing Act 248 definition. So the court has all those evaluations, and then it's up to the court, based on what the state's attorney can demonstrate by clear and convincing evidence. If the state's attorney does demonstrate, and I just mentioned this, the person's dangerous, and remember, they're non-restorable, then you see the very top line of the page. If that's the case, then there's continued treatment consistent with the person's forensic risk assessment. So in other words, that treatment could be at the facility, but it might not necessarily be, because the forensic risk assessment could be, dangerousness is a sort of a sliding scale, might be some sort of other placement that would be appropriate. And you'll see that language added specifically, court shall order treatment, which may include appropriate supervision and housing in the least restrictive setting consistent with the forensic risk assessment and treatment. So if that risk assessment is highly dangerous, shouldn't be released, likely to stay at the facility. If the risk assessment could safely be released under conditions, then that could be an option as well. And again, I mentioned that type of continued commitment is reviewed every 12 months. Agency of Human Services Medical Director has a role in determining whether or not, and it's similar to the role I mentioned in the first instance. It's every 12 months, or it could be sooner if the medical director sees a reason to evaluate it sooner.
Does the Agency of Human Services actually have a medical director? The Agency of Human Services? I mean, there's medical directors in various departments, but I'm not familiar with the Agency of Human Services medical director.
I think the witnesses would be able to answer that question more directly, but my understanding from testimony in House Judiciary was that the position is currently posted. I think that's what was testified to.
The position is currently posted.
That's what I understood.
It's a new position, in other words.
I can't answer that.
Okay, thank you.
Yeah. So then if the essay does not demonstrate by clear and convincing evidence that the person is dangerous, then the court has to order the release of the person. Okay, so that's where we're in now. The person is not, their competency can't be restored, and they're not dangerous, so they are released. And there's this list of conditions that have to be or can be applied and set recommended by the medical director and then ordered by the court. That's the process. Person is released, and then the person who is released is what's the word monitor there? Well, I just mentioned the periodic review every 12 months. And again, at each of those hearings, the state's attorney has to demonstrate by clear and convincing evidence that they would be dangerous or they stay out in the community. There's some language here about victims having the right to appear at these proceedings and present their views. So that is like standard language that committees have seen in various court processes. So now we're at the piece here. Remember I mentioned, so this is the part where the person could get transferred and recommitted to Dale. So because they've been found non-restorable, right? And the court could find them dangerous and keep them in the facility, not dangerous, release them under condition of supervision, or option 3, send the person back to Dale if they meet that definition of person needed custody, care, and rehabilitation. And that's the intellectual disability language that I'm sure the committee is very familiar with. And now all this language here again is tracked verbatim from the existing commitment to Dale language that's in the criminal code in Title 13. So that same finding, the same qualification for the person if they are committed there They have the same rights in terms of receiving care and rehabilitation, applying for judicial review of their cases, et cetera. All that language is just existing law in Title 13 now at the front end of the proceeding, of the criminal proceeding, now placed here so that it's a possible off-ramp for a person who's at the forensic facility or a person who just got there. Now, you'll see though, one line here, just I want to point out. So the person you see, the court shall commit the person to jail, and this is, let's get that bottom two lines of this page, unless subdivision B of this subdivision 6 applies. So just to point out how that works. Well, what is subdivision B? Well, if the commissioner certifies that appropriate custody care and rehabilitation can't be provided. Now that's language again, that's right out of the current statute and the current definition of a person in need of custody care and rehabilitation. That the commissioner has to certify that their designated program can be provided. But if, in this case, if the commissioner certifies that it can't, that that level of care can't be provided, then the person isn't committed to jail custody, and the court orders continued treatment at the facility until the commissioner does provide this designated setting program in the least restrictive setting. So
is that part of Act 248 now? The commissioner being able to certify that they don't have an.
No, that piece is different. But the initial definition is, in order to be committed in the first place, the commissioner has to say that there is this appropriate level of care available. But this certification process, that part is not in the, at least not that I'm aware of.
And so it's not saying permanently, it's saying until an appropriate program is developed, essentially. Is that what it's saying?
You mean not permanently at the facility?
At the facility.
Yes, that's right. That's right. And there's an opportunity for review.
Every 6 months.
Every 6 months, or you'll see subdivision 2 every 6 months, and the person has the right to petition themselves at any time, either 90 days after or not less than 6 months after the filing. And that language actually is from Act 248. That's the same opportunity for review that the person has under Act 248. And there's a third, in a sense, review ability here, and that's down in subdivision D. So at any time, regardless of that 6 month period or whether the person has initiated their own review process, the commissioner can say, we've got a designated program available, let the court know. The court then vacates the order and sends the person.
Well, and I mean, it is logical to presume that it would take time for a community program to be developed. So I get that.
So I just want to be clear, the commissioner you're referring to is Commissioner Dale?
Yes, that's actually subdivision E there. In this subdivision, that's. I see it missing, oh, sorry, probably my draft, missing quotation mark.
All right, go ahead, Representative McGuire.
Hey, thank you. Just clarification purposes, from what I'm reading, right, and I mentioned back in previous testimony, my significant concern with the governance. It seems like, and please, there is distinction that there is custodial authority and clinical authority separation. Is that a fair statement? From what I'm reading, that seems to be the case. I just want to get that verified. Is that the case at this time? There is clear governance separation between the clinical authority and.
Yeah, I think you'll see later in the bill that it's the Agency of Human Services medical director that is responsible for the clinical decisions, the treatment decisions, that sort of thing. So yeah, I think that is set out as part of that role's responsibility, as opposed to the sort of custody.
The clinical director previously was answering to the Commissioner of Corrections, which didn't have that dual governance separation. Now, what I'm reading within this language, that is the case, just getting that verified.
Yeah, the medical director would be answering to Agency of Human Services, which certainly does include the Department of Corrections. But yes, it's an intent to sort of bifurcate that treatment role and the custodial role.
Thank you.
Yep. All right, so this is just some language I think the committee has looked at previously, that while the person is at the facility, they get competency restoration services, generally speaking. Could be at another facility, that they're provided at the facility. again, this is some joint authority because, as I mentioned, the person could be under the supervision of one of a number of different departments, depending on what condition they have. So you'll see here, this is who monitors. If the person's released, who monitors the person? Well, that will depend on the needs of the person. As appropriate for the needs of the person could be mental health, could be Commissioner of Health or Dale Commissioner monitors compliance with orders. And if the person is determined by, again, it's the medical services director has reason to believe that the person has become dangerous again, then they can be returned to the facility after they've been released to the community. Commissioner notifies the court if that happens, and the court has to have an additional hearing to determine whether they should either stay at the facility or be re-released to the community. This is the involuntary medication piece that has been in the bill for some time. No changes here other than, again, clarifying that it's the medical services director, because then that's a medical treatment issue. Medical services director has to get prior approval from the court, and clarifying that the state's attorney has the burden of establishing that by clear and convincing evidence that involuntary medication is appropriate, medically appropriate. This is
Will you just remind me where clear and convincing comes in the hierarchy of?
it's in the middle. So it's above preponderance, which is more likely than not, but below beyond a reasonable doubt, which no reasonable mind could differ. So yeah, so I think it's often referred to as substantial likelihood.
It's in the middle.
It's in the middle, right?
No, I represent Donahue hat on, right?
It's a good question. Also providing new language to see subsection I, making clear that for any of these evaluations, the defense can be has the right to conduct their own independent evaluation and introduce that results at. This section 2 is more of a criminal procedure issue. We can look at it if you want, but it's I don't know if the committee has really been looking at this or not. It just provides the criminal court with the authority to dismiss certain criminal cases when there's been an incompetency finding and a misdemeanor, and it's been pending without any action for a long period of time. And this is the second universe of people that we're referring to. We just went through all the folks who were found incompetent to stand trial. This next section deals with people who were not guilty by reason of insanity, and to be honest, all these changes are exactly the same as the ones you already looked at. They're not as many, they're very few, because the proceedings are much more, there's that off-ramp for Dale supervision, that sort of thing exists in the competency context, but does not exist in the not guilty by reason of insanity. Because remember, in this case, there is no pending criminal charge anymore. And the only authority is that the criminal division is, actually, you see that right there, subdivision 2. The committing court, that's criminal division, shall retain jurisdiction of the person for all proceedings under the section. Because without that language, it's arguable whether the court has jurisdiction over this person anymore, because they've been found not guilty. So there's no criminal charges pending anymore. So anyway, a different range of people who are subject to this, but the language is very similar. You'll see that same language in the forensic risk assessment that the evaluator has to make. Establishing the requirement the state's attorney established by clear and convincing evidence that the person's dangerous. Clarifying again that it's the medical director who's making these recommendations regarding the person's custody and dangerousness. The review here, the review periods are different if you're not guilty by reason of insanity. Rather than every 6 months, it's 6 months initially, and then the periods are longer. 3 years after the commitment order, and then 5 years after a commitment order. But a different piece of this is that the person can themselves apply at any time. That's subdivision B there. They can always ask for a review. Again, establishing this burden of proof that we've been mentioning all along, convincing. And then it's the medical director who is making the recommendations for how the person should be treated when they're released. Pause me if I'm going too fast, but I think that's all stuff that we already went through the first time. And now we're getting to some of Katie's language on the forensic facility definitions.
So in section 5, House Corrections and Institutions was interested in a definition of forensic facility that came from a previous bill, a previous act, dealing with the forensic facility. So I've tried to integrate some of the language from that definition into this definition here. One aspect of that definition is it has the forensic facility licensed as a therapeutic community residence. Human Services raised that not all aspects of the therapeutic community residence rule are the right fit for a forensic facility. So you'll see language later when we're looking at the feasibility plan that's asking about what specific amendments or waivers of the therapeutic community residence rule would be required to make it an appropriate fit for the forensic facility. So now as a definition, we have that the forensic facility is licensed as a TCR where a person is transferred pursuant to either of the two sections that we just looked at with Eric, either not competent to stand trial or not guilty by reason of insanity. AHS would provide competency restoration, evaluation, stabilization, treatment, and care for an extended period of time to persons with a mental health condition. Again, still wondering who the complete population is who will be served here, who are involved in the legal system and who do not require a hospitalization level of care. So that is trying again to integrate a definition of forensic facility that was used several years ago in a previous act with the current content of what you're looking at in this bill.
So Katie, what's highlighted in blue comes from Healthcare Committee?
Yes.
Okay.
And I should be clear that they had a conversation and gave me some marching orders yesterday, and they have not circled back to look at this language yet. So this is sort of making educated guesses, but they really liked the phrase, and you'll see it repeated a few times: competency restoration, evaluation, stabilization, treatment, and care, to reflect what would be the types of services that would be occurring within the forensic facility. So that is where that language is coming from.
We do have Representative Rebecca here from Household Care in case there's any questions about that.
And then the green for the extended period of time.
That comes from the statute that your committee was,
The previous act definition.
So I want to make sure that I'm being clear about this because I'm trying to figure out how this comports to the previous sections that we were just looking at. So this says with a mental health condition.
and that is taken from the language in the previous act that did not include individuals with intellectual disability. So I guess I would flag that, you know,
Okay.
as we.
I just want to make sure that I'm looking at, that I am interpreting what's written here with, you're flagging it as distinct and separate from what's above, which is important for us to flag.
Yes.
I personally don't have a problem with this language. I'm just making sure that I was reading it in the way it was intended. That's all.
So how does this work with the front part of the bill?
I think that I'm awaiting clarity from all four committees as to what you would like to see in this section.
I it's not.
I think we both are.
Yeah, yeah. That's fair. Thank you for flagging it.
That's the other. committee.
We'll be back.
Not us.
We'll be back, yeah.
Okay.
Representative Emmons does not want to, you know,
I'm not.
she doesn't want to come between
No.
other policy committees and judiciary.
Not our lane. My lane.
I like that you inserted it though, Representative.
Yeah, well, just to kind of, we went back on previous definitions of forensic facility. And that's what's incorporated here. It already had passed. It was, which one was it? Act 27?
Act 27, you're gonna ask here, maybe 2024?
Yeah, and we just wanted, we had this in the Senate version, a definition, and then what had already passed, it became law. We wanted to incorporate portions of that definition into the definition that was in the Senate bill. Now, that's up to you folks, your policy folks. And those previous definitions came from the policy committees, not from corrections and institutions. Want to be clear about that.
Yeah, I got
So subsection B, this is language, that talks about the different, services that will be provided in a forensic facility, what a forensic facility might look like. You'll see the language, a lot of language isn't highlighted. This all came from Senate Health and Welfare and Senate Institutions originally. But some like committees have looked at it since then and added language. Just a reminder of where we were, this would be in the green books. So this would be statutory language that governs what a forensic facility would look like. You also have a section that's a feasibility plan. So I know there have been a lot of components discussed. So if you don't see something in this list, it could be that it's something that you're wanting more information back on. So we have Secretary of Human Services. It's operating a locked and secure forensic facility. That phrase again, that came from healthcare for competency restoration, evaluation, stabilization, treatment, and care of a person who's been transferred pursuant to the two sections that Eric went over. You have language from House Judiciary that the facility's forensic, clinical, and competency restoration services shall be overseen by the AHS medical director. And then we get into this list itself, the forensic facility shall. So we have that it will be designed and operated in a manner that supports therapeutic, recovery-oriented, and trauma-informed programming in a therapeutic community residence to reflect the definition that was added up above. No changes in 2 and 3. Provide safe evaluation, treatment, stabilization, and care of persons, including the ability to separate the population by sex or gender and otherwise address clinical, safety, or operational needs as appropriate. And 4, another change by House Judiciary, follow the directions of the AHS medical director instead of the clinical services director to oversee these services. No changes in 5 or 6. And 7, ensure that persons receive clinically appropriate assessment and treatment planning and competency restoration plans as appropriate. New items from House Healthcare. Ensure that clinical services and programming include psychiatric care, management of medications, education about court procedures, habilitation and trauma-informed care. Continue to provide evaluation, treatment, stabilization, and care of a resident who has regained competency while the resident awaits states in the resident's trial. That's the conflict that I flagged for you earlier. Provide residents with interpreters as appropriate and implement grievance and appeal procedures. So I'm going to skip ahead. Do you want to cover changes in?
Oh, yeah, sure. So this is the consultation, because remember, as Katie was just saying, it's the Secretary of Human Services that's has the overall operational responsibility for the facility. But this subsection E requires that they consult with the Commissioners of Corrections, Mental Health, and Dale while performing all their duties under the chapter. Also clarifies that it's the Agency of Human Services Medical Director. I've been reading this for too many times, evidently. Who submits the reports that are required by this section, and that's the Secretary that adopts the rules.
This section,
Can I
pause.
just hold here in terms of the on the right section 5, what we were working on. That becomes effective January 1st, 2028. So keep that in mind when we start talking about the feasibility plan. I looked on the back, we've still kept it. Section 5. We just went through, takes effect January 1st, 2028. So keep that in mind in terms of the flow of time with the piece of that's later on.
Okay, so I'm gonna cover this section 6. This section 6 is not exactly what House Healthcare talked about. I made some educated leaps based on the conversation. So who knows if they're going to like this when they actually see it. They had a concern that they wanted the mental health care ombudsman to have authority over individuals that were in the forensic facility. When I looked at that statute, it didn't list the specific types of facilities that the ombudsman would oversee, but it did say that according to this statute, that they would have different types of reportable events reported to them based on facility type. So I instead amended this section to include forensic facility as one of the reporting facilities to the ombudsman about different types of death, instances of death or serious bodily injury to individuals with a mental health condition or psychiatric disability who are in the custody of the care of the commissioner. So that's how I handled that. And then we get to the feasibility plan. So this concept originated with corrections and institutions. Healthcare had some additions, and I added an addition from human services that was discussed when I was in the room. So we have this coming back January 15 of 2027 from the Secretary of Human Services. This is a feasibility plan to develop and operate a forensic facility, and it's coming to 7 different committees in the General Assembly. It addresses the following: the proposed location of a forensic facility, which is to be independent from a correctional facility, and if on the same grounds as a correctional facility, separated by sight and sound. The proposed design plan for a forensic facility that allows for the ability to separate residents by sex or gender and clinical need. The number of beds within the forensic facility. The entity or entities responsible for operating and providing services in a forensic facility, which shall not be DOC. Top of the next page, timeline for constructing a standalone forensic facility or fitting up an existing standalone facility to operate a forensic facility. Estimated cost of constructing or fitting up a forensic facility. Which aspects of the therapeutic community residence role would need to be waived to operate the forensic facility as a TCR? This could be also highlighted in pink because the same issue is raised in human services. Clinical services available at a forensic facility, including on-site competency restoration services. The proposed staffing levels, staff qualifications, and potential contracting needs necessary to establish a multidisciplinary clinical team at the forensic facility that reflects best practices, including required trauma-informed staff training and multiple potential staffing strategies. Subdivision 10, physical and staff security plan, both within and around the perimeter of the forensic facility, including therapeutic design and clinical supervision that reflects best practices. Subdivision 11, resident discharge and community monitoring plan from each department with custody of individuals in the forensic facility that prioritizes community safety and provides residential, clinical, and case management services. And that was a concept discussed in human services, the residential, clinical, and case management services of somebody when they left a forensic facility. Subdivision 12, whether any opportunities exist for out-of-state placement of the forensic facility population and clinically appropriate programming while the development of a forensic facility in Vermont is pending. From Human Services, a plan for the expansion of Act 248 to include individuals with a cognitive disability. Subdivision 14, annual reporting metrics on the demographics, outcomes, and staffing of the forensic facility. House Corrections and Institutions made a decision to pull out the annual report that came over from the Senate. The conversation that the cart was sort of before the horse, and if we don't know what the program looks like, we don't really know what we're should be asking for in terms of metrics. So healthcare has asked that part of the plan is for the administration to provide which metrics are appropriate for collection on an annual basis. Subdivision 15, any recommendations for legislative action to effectuate the development of a therapeutic trauma forensic facility. And then, as we said, this plan is coming back next January, but there are 2 check-ins prior to that. So August and November of 2026, there are meetings of the Joint Legislative Justice Oversight Committee At which point the Secretary of AHS or designee would provide an interim status update on the development of this feasibility plan.
I'm sorry, go ahead, Representative
I'm
Stein.
just curious, well, the deputy attorney's here. Are all the committees on board with having the Secretary of Human Services? Because to me, Commissioner of Corrections would make more sense to take jurisdiction. So are all 4 committees wanting the Secretary of Human Services? Or is there a certain committee?
I could answer that the 3 committees I've spent time in have all indicated they're not supportive of the Department of Corrections.
That's fine.
I think there's maybe still an open question whether it should be AHS or if there should be multiple departments providing the hybrid support. I don't know that that has been fully resolved yet.
Okay, just curious.
The Committee of Jurisdiction for the Department of Corrections. There,
Right.
why don't you
So
say?
yeah, this language came from us because we have some real concerns about folks being housed in our correctional facilities and under the custody of the Commissioner of Corrections. It's a very different world than folks that need medical care. And we know that our staff, correctional staff, they're just not trained in working with folks who may be incompetent to stand trial or not guilty by reason of insanity. And that's why we're saying, come back with a plan. It's not a study. It's not a study. We want to be really clear about this, because there's been multiple studies, nothing has been acted on. We want something to be acted on. We're asking the Agency of Human Services, since we're dealing with folks who are under the custody of different departments, to come back with a plan to carry out a forensic facility. This becomes effective July 1st of this year. You got to come back to plan from January. Next January, we're having the Justice Oversight Committee get updates twice while we're off session. And then if we start working on this again next session, because that's the thinking, we have the plan that will be presented. Legislature will work on it next session. And then the definition of the forensic facility that we just went through takes effect January 1st of 2028. So the plan's gotta come first. What's your facility gonna look like? And you have to meet 1 through 14 now, in that plan.
So the other thing that I'd want to add to this on number 6, the estimated cost of constructing or fitting up constructing or fitting up a forensic facility. We need to add operating. I don't want to get into the same situation that we've been in around the youth facilities. So operations would need to be added to that.
And Katie, we also have to include BGS in some part of this, because when you're talking about the cost and number of beds and the design, we've got to somehow include BGS being involved.
Okay, I'll have the secretary consult with BGS.
BGS doesn't have to get involved with all of it, but certain sectors that they have to work.
Thank you for taking a look at this with us and for responding to all of our questions. This is the first time my committee's sort of seen an outline of the full bill.
Same here.
Me too, yeah. So obviously the chairs are going to have to put our heads together and make some decisions about timing and ownership and amendments and all of that. We'll be back in touch about that. And I think we're ready to go
Finish
offline.
up.
Yeah.
Thank you.